Magandang araw po sa inyong lahat at welcome po sa isa na namang video ng Payo ng Abogado. Para sa module na ito, pag-uusapan natin ay ang philosophy of law regarding an imbecile or an insane person. Simulan na po natin. Philosophy of law regarding an imbecile or an insane person. In the case of People of the Philippines versus Lito Panya E. Anandan, the Honorable Supreme Court specified the following philosophy of law. Number 1. In the case of People of the Philippines versus Abelardo Formigones, the accused was charged with parricide for stabbing his wife. He interposed the defense of insanity under Article 12.1 of the Revised Penal Code, alleging that during trial, guards of the provincial jail testified that the accused exhibited strange behavior and behaved like an insane person during his incarceration. There, this court rejected the defense of insanity, citing decisions of the Supreme Court of Spain. It held that for an accused person to be regarded an imbecile within the contemplation of the revised penal code, there must be complete deprivation of reason, discernment, or freedom of the will at the time of the commission of the crime. In order that a person could be regarded as an imbecile within the meaning of Article 12 of the Revised Penal Code so as to be exempt from criminal liability, he must be deprived completely of reason or discernment and freedom of the will at the time of committing the crime. Number 2. The allegation of insanity or imbecility must be clearly proved without positive evidence that the defendant had previously lost his reason or was demented a few moments prior to or during the perpetration of the crime. It will be presumed that he was in a normal condition. Acts penalized by law are always reputed to be voluntary, and it is improper to conclude that the person acted unconsciously in order to relieve him from liability on the basis of his mental condition unless his insanity and absence of will are proved. Number 3. The formulation in Formigones gave rise to two distinguishable tests in determining the existence of legal insanity. Number 1, the test of cognition, and number 2, the test of volition. The test of cognition requires a complete deprivation of intelligence in committing the criminal act, while the test of volition requires a total deprivation of freedom of the will. Despite the existence of these standards by which legal insanity can be measured, a review of jurisprudence shows more reliance on the test of cognition. Number 4. But our case law shows common reliance on the test of cognition. Number 5. As expounded in People versus Hallock, the defense of insanity rests on the test of cognition on the part of the accused. Insanity, to be exempting, requires the complete deprivation of intelligence, not only of the will, in committing the criminal act. Mere abnormality of the mental faculties will not exclude imputability. The accused must be so insane as to be incapable of entertaining a criminal intent. He must be deprived of reason and must be shown to have acted without the least discernment because there is a complete absence of the power to discern or a total deprivation of freedom of the will. Number 6. In previous cases where schizophrenia was interposed as an exempting circumstance, it has mostly been rejected by the court. In each of these cases, the evidence presented tended to show that if there was impairment of the mental faculties, such impairment was not complete as to deprive the accused of intelligence or the consciousness of his acts. Complete deprivation of intelligence has been equated to defect of the understanding, such that the accused must have no full and clear understanding of the nature and consequences of their acts. Number 7. Deprivation of intelligence, however, is not a symptom of every mental illness. Number 8. The Supreme Court of Spain likewise held that deaf muteness cannot be equal to imbecility or insanity. Number 9. The complete deprivation of intelligence or will test originated from the Old English concept of wild beast test, which likens defendants to wild beasts due to their complete lack of understanding of their actions. English jurisprudence held that, to be insane, an accused must be totally deprived of his understanding and memory so as not to know what he is doing, no more than infant, brute, or a wild beast. This test placed more emphasis on the accused's cognitive capacity rather than impulses and raised the criteria which effectively reduced the rate of acquittal in insanity defense cases. Thank you for finishing this module. Let's move on to the next one.